The Human Rights Commission makes administrative rules that are used as a guideline to work from, creating a code of conduct, so to speak. Now, the legislature makes laws and the Human Rights Commission makes administrative rules that are used within the framework of the legislative laws that are enacted. The Human Rights Commission was given power to make administrative rules, and they have the power to change those rules, but in most cases, they don't or won't change them, even though they have the power to do so. Remember, these are not laws. These are administrative rules. They don't involve the legislative branch of government. The Human Rights Commission has knowingly made an administrative rule that is out of balance with the equal protection of the law set forth by the United States statute, which states that all its citizens shall equally be protected by law. It didn't say all but independent contractors shall be protected, separating them. Insomuch, the Human Rights Commission has knowingly committed an injustice by making an administrative ruling that separates the independent contractor and taking away his protection under federal law, and federal law supersedes any administrative ruling by the Human Rights Commission. This body therefore has an ethical duty to overturn this unjust rule that has been created. It's taxing the taxpayer and the judicial system because the independent contractor has to resort to paying for his own defense, thereby being punished even more. When the Human Rights Commission was created, their very purpose to protect people, but they often find no fault when there is fault. The Human Rights Commission, by this administrative ruling, has undone what people have died for, what people have fought for, to get equal protection under the laws governing these United States, and makes them in complete violation of federal law, which grants equal protection to all, to include the independent contractors as well as all others. Separate but equal protection was overturned in the United States long ago, and separate is still against the law. Separate but equal is what the Human Rights Commission is saying by keeping this rule, this administrative rule, in action. We the people includes the independent contractors of America. We also have the rights as Americans to have equal protection of the law.
Disparate treatment by Washington State Departments. As you know, the last time that I spoke before you, I believe you were up by Everett, I believe, and that's where I introduced this topic about disparate treatment in some of the Washington State departments. One thing that I used as an example of disparate treatment in the Department of Health was this event right here, an event where a white doctor was alleged to have willfully misrepresented or dishonestly made false statements about a black physician, and the Department of Health construed that action as not representative of unprofessional conduct. The Department of Health construed that this action was beyond its jurisdiction, and indeed that is wrong. Unprofessional conduct is defined by that RCW. It's basically the commission of any act involving moral turpitude, dishonesty, or corruption relating to the practice of the person's profession, whether the act constitutes a crime or not. And we see that in Washington State Supreme Court that we know that an act of moral turpitude is one which violates commonly accepted standards of good morals, honesty, or justice. And we know that to constitute unprofessional conduct under that law, the act must indicate unfitness to bear the responsibilities of and enjoy the privileges of the profession. It all seems to be kind of well understood, and we should all be able to grasp that. Now the conduct that may indicate unfitness to practice the profession, if it raises a reasonable concern that the individual may abuse the status of the profession to harm the public, or it lowers the standing of the profession in the eyes of the public. And this right here is from the Washington State Supreme Court, and this is really instrumental in bringing out why the actions of the Department of Health are wrong. That's because conduct may indicate unfitness to practice a profession without being directly related to the specific skills needed for that practice, and need not have occurred during the actual practice of professional skills. Now, on that, what I did not include in your packets were actually some position statements. During the time from Everett to today, I was able to get some assistance from persons like Senator Karen Kaiser, who is our 33rd, or the senator for the 33rd Legislative District, and she did some investigation and queried the Department of Health as to why it would rule that a doctor who makes false statements about another doctor is not construed as unprofessional, and how they interpreted the law. And I have that here. I also talked with the Commission on African American Affairs and NAACP, and both the president of the NAACP and a commission member, Oscar Eason, drafted a letter on behalf of the commission, also to the Washington State Department of Health, to ask them basically what was up. And the Department of Health responded, and it said that basically it construed as it did because the actions did not involve healthcare delivery. In other words, the doctor didn't have his hands on a patient, wasn't prescribing any medicine. He only did it in his role as chief of staff while talking to an HMO about the other physician. And that because he wasn't actually laying hands on a patient or performing his skills, they thought it was outside of their jurisdiction. Now, what I have offered you, and what I did provide to you, is actually the State of Washington Department of Health Medical Disciplinary Board's decision and order motion for summary judgment regarding an Elliott V. Oppenheim, MD. And what that case does, it actually lays down quite nicely how one is to construe unprofessional conduct. And that is actually how the Department of Health's Medical Quality Insurance Board does it. There are many references, unfortunately, to physicians who lost their licenses because of unprofessional conduct, and they all refer back to the same way to construe it. And indeed, the position statement that was written to the senator, the position statement that was written to the Commission on African American Affairs is different than what it appears, and that's why I say that the Department of Health constructs are utterly false and are pretext to hide discriminatory practices. We know that to be unprofessional, the conduct only need be related to the practice of medicine and not to healthcare delivery. That's in the statute, the language of the statute, which is there for you, RCW 18.130.180. And of course, the matter of the disciplinary action concerning Elliott V. Oppenheim, MD, which I've already referenced. We know that the practice of medicine is also defined by statute. It's defined as offers or undertakes to diagnose, cure, and I've bolded the word advise because that's what the doctor did in their capacity as chief of staff. They advised the HMO about another doctor. Or prescribe for any human disease, ailment, injury, infirmity, deformity, pain, or other condition, physical or mental, real or imaginary, by any means or instrumentality. That's the practice of medicine. So, the Department of Health did not tell the truth. The white physician dishonestly advised an HMO that the black physician killed a patient, though that patient is still alive today. Now, the alleged conduct was related to healthcare delivery, even though this was not a requirement. Again, they had stated that because the doctor wasn't delivering health care, didn't have his hands on a patient, didn't prescribe any medicine, that type of thing was how they viewed it. But we know that from statute, they have definitions for health planning and development, and that's found in RCW 70.38.